Welcome back to Clause for Concern, Notwithstanding Canada's Charter. We're a couple of episodes in, and hope you're starting to get a better sense of the state of the Notwithstanding Clause, because, surprise, things are about to get even more complicated. Today, we're taking you to Quebec, where the Notwithstanding Clause has been invoked numerous times, sometimes without much fanfare. Recently, though, the use of Section 33 to pass Bill 21 has ignited a renewed national discussion on whether the clause's use should be subject to greater scrutiny. Before we get there, however, it's worth asking how Quebec's relationship with the Notwithstanding Clause has evolved since its first invocation in 1982. To do this, we sit down with the University of Montreal constitutional law professor Jean Leclerc to discuss the unique position of the Notwithstanding Clause in Quebec's constitutional culture. We then delve deeper into the controversial Bill 21, which bans certain types of public workers, such as teachers and police officers, from wearing religious symbols on the job. The result of this is that affected individuals are left in a difficult position. Either they disregard their religious beliefs, change career paths, or move out of Quebec. To understand the secularism law and the ongoing litigation over its constitutionality, we talked to C. Strauss, a senior staff lawyer at the Women's Legal Education and Action Fund, also known as LEAF. On behalf of LEAF, C unpacks the consequences of Bill 21, how claimants have challenged it in court, and what remedies may be available to those affected. Hello, John. Welcome to the podcast.
Hello, Saloni.
As you know, this episode is about delving into how Quebec has used the Notwithstanding Clause throughout the years. We've heard in previous episodes about Quebec's unique relationship with the clause, but maybe you could give us a brief summary of how the province has used it since 1982.
Okay, well, before 2017, the government of Quebec inserted a derogation clause to the Quebec Charter in 32 statutes and a derogation clause to the Canadian Charter in 18 statutes. Now, if we try to describe the circumstances leading to the use of the Canadian Notwithstanding Clause, we find the following. First, it was used to protect back-to-work legislation, establishing a presumption of guilt for those not returning to work on time, and the derogation clause aimed to discard the right to be presumed innocent until proven guilty. Second, it was used to prevent a challenge to statutes providing special treatment for vulnerable segments of society. For instance, some protected statutes dealt with pension plans containing special measures benefiting women, or dealt with rights and privileges granted to religious denominations in matters of education. And the clause was also resorted to in order to protect agricultural subsidies aimed at young farmers from being challenged under Section 15. Now, what is important to underline here is that most of these protected provisions would have stood a good chance of being upheld under Section 1 as a reasonable limit. As you remember, Section 1 of the Charter allows for reasonable limits in a democratic society. The use of the Notwithstanding Clause was therefore, in those cases, superfluous. However, it aimed at preventing costly challenges. Thirdly, and most controversial, was the use in 4 instances of the Notwithstanding Clause to protect Quebec's distinct Francophone status within Canada and North America. So, first instance, the 1982 Act Respecting the Constitution Act 1982 inserted, through an omnibus bill, a derogation clause in all existing provincial legislation to protest the patriation of the Canadian Constitution without Quebec's consent. So it was adopted few days after the enactment of the Constitution Act 1982. In that case, and it's important to underline it, only the notwithstanding clause of the Canadian Charter was triggered. So the Quebec Charter remained applicable to challenge legislation violating human rights. You'll see the difference between what is now the process adopted by the present Quebec government, where it uses both notwithstanding clauses. By the way, the derogation clause was not renewed. As you know, the derogation clause has to be renewed every 5 years, and that clause was not renewed at the time. Second instance of using the notwithstanding clause to protect Quebec's distinct francophone status was the 1988 Act to amend the Charter of the French language, which protected the said charter's provisions requiring French-only commercial signs that had been declared invalid in Ford. Let's recall that in Ford, the Supreme Court stated that Section 33's implementation was subject to purely formal criteria and not to substantive ones. And in that case also, the derogation was not renewed 5 years later in 1993. And now, more recently, in the third instance, the notwithstanding clauses, because both the Quebec's notwithstanding clause and Canada's notwithstanding clause were introduced in the 2019 Act respecting the laicity of the state. You might recall that this statute prohibits person exercising certain state functions from wearing religious symbols in the exercise of their functions. And very controversially, the preamble of the law states that state laicity should be affirmed in a manner that ensures a balance between the collective rights of the Quebec nation and human rights and freedoms. And so there's this weird opposition between the collective rights of the Quebec nation, and generally rights are opposed to a stronger party. Quebec could have collective rights against the rest of Canada, for instance, but using collective rights as a means to counter individual rights is very problematic because the majority does not enjoy a collective right against the minority. The majority just exercise pure power. And that's why individual rights exist, to counter the power of the majority. And this recourse to the notwithstanding clause was recently upheld by the Quebec Court of Appeal in the Hack case, in which Quebec's highest court felt bound by the Ford decision. And they said, well, it's a purely formal criteria that were met, and so it was held to be valid. And finally, last but not least, a derogation clause is found in the 2022 Act respecting French, the official and common language of Quebec. And these are the four most controversial use of the notwithstanding clause, Canadian notwithstanding clause in Quebec.
I know it's difficult to define how a particular political community feels about an issue, but do you think that there's a dominant view of the notwithstanding clause in Quebec? And assuming that there's some resistance to this view, what are some of the different opinions within Quebec's legal and academic communities?
Well, many academics in Quebec agree about the legitimacy of the recourse to both notwithstanding clauses to protect matters held to be fundamental to Quebec's francophone and lay identity. But I wouldn't say there's a dominant trend. I mean, the Quebec legislature has also been more eager to resort to Section 33 than other provinces. However, there is no unanimity among Quebec scholars about the appropriateness of resorting to notwithstanding clauses. There is no school of Quebec versus a school of English-speaking Canada. I know there might be unanimity among sovereignist academics in Quebec, but that's all. And I know that some sovereignist academics claim that there's a moral right for Quebec to resort to the notwithstanding clause, but they don't represent the whole of the community. And powerful voices, such as that of Jacques-Yvan Morin. Jacques-Yvan Morin used to be a vice premier under Legault government. So he was a staunch sovereignist, and he criticized the Quebec charter, the Quebec's charter's notwithstanding clause. And other well-known constitutionalists in Quebec, maybe not that well-known outside, but someone like José Verling, for instance, has been critical of the Canadian notwithstanding clause. And in the current debate, Robert Legault, Dean of McGill Law School and definitely a Quebecer, stands out as one of the main opponents to the idea that Section 33 prohibits courts from assessing the constitutional validity of challenged legislation. Other scholars debate the validity of Legault's position without being enthusiastic defenders of the derogation mechanism. So the situation is not monolithic in Quebec. Legault and those who share his opinion believe that the Ford case is not the final word on Section 33. They believe that a notwithstanding clause does prevent a court from declaring a provision invalid or inoperable. However, they claim that a court might still issue a declaration of inconsistency or incompatibility. The offending provision would then remain in force, but would henceforth bear the stigma of a judicial condemnation. And some academics also argue that Section 33 should not be used preemptively, but only after a court has declared a law invalid. And in both of these situations, the court's reasons, it is argued, would feed into the democratic debate that should take place after 5 years when the question of whether or not to renew the notwithstanding clause would arise. So that's the main theory of those who say that Section 33 is not the last word. As I repeat, they recognize that the court could not declare the law unconstitutional, but they could declare it incompatible with the charter. And these approaches are based on a democratic theory of constitutional law. One according to which democracy it's not just a mechanism to decide who rules at the time of the election, but that democracy is also a tool for deliberation, the need for deliberation about complex societal issues. But this approach, Legault's approach, was rejected, in fact, by the Quebec Court of Appeal in the Hack case, and also by the Ontario Court of Appeal in the Working Families Coalition case. But it was embraced, as you might know, by the Saskatchewan King's Bench in a case called UR Pride Center for Sexuality and Gender Diversity. I wish to underline that the debate around Section 33 has been framed as a battle between courts and legislatures. And in the words of Brian Slattery, a great constitutional scholar that you might know, who's at Osgoode Hall Law School, Brian Slattery, in the words of Brian Slattery, the debate is focused on the judicial model of the Charter as opposed to a collaborative model of the Charter, in which the responsibility to protect human rights falls not just to courts, but to both courts and legislatures. The latter have a duty to assess how rights might be promoted, not only how they should be limited. And some scholars like me, following Brian Slattery's path, do not consider the derogation mechanisms illegitimate, but argue that its too facile implementation deprives it of legitimacy. According to me, it would be for the legislature to adopt an act that could be called the Act to Implement the Notwithstanding Clauses that would provide, among other things, that the derogation clauses should only be used ex post facto and not preemptively, and should be subject to the approval of 2/3 of the sitting members of the legislature. So I think it's not for the courts to introduce these criteria, but it would be for the legislature, the political actor, to assume its responsibility to protect human rights and provide more legitimacy to the recourse to Section 33 by adding these conditions to its implementation.
Some scholars have suggested that there's something different about the recent uses in Quebec. I'm thinking particularly with Bill 21. Do you think uses like this are concerning?
Yes, it is concerning, but one must adopt a more historical sociological perspective to understand the debate in Quebec. One must recognize that the discourse over whether or not it is legitimate to resort to Section 33 is set against the background of the Charter's overall illegitimacy in the eyes of many, because Quebec has not consented to patriation. That's why the Legault government enacted in 1982 this blanket application of the derogation clause to all the statutes of the province. It was to condemn, to protest this the fact that Quebec had not consented to patriation. One must realize also that the nature of Quebec nationalism has changed over the years from what it was in 1982, from what it is right now. Just a word of context to understand the strategy of the current Quebec government and its success with the French-speaking majority of Judeo-Christian tradition, now almost all entirely secular, by the way. You must understand nationalism. To survive, nationalism must be based on a feeling of injustice and resentment. And this feeling must be exercised against another, an adversary, an enemy. Confrontation can, of course, take peaceful forms, but the existence of an enemy remains the existential condition of nationalism. For a long time, the rest of Canada, that is English-speaking Canada, was the enemy of Quebec nationalism. So was the federal government. And this first type of nationalism was quite emancipatory in that it aimed to lift Quebecers out of their status as second-class citizens and aimed to diminish the attraction of the English language for newly arrived immigrants to Quebec. And this form of nationalism enjoyed great success from the 1960s onwards and enabled French-speaking Quebecers to mobilize effectively. Today, for instance, French-speaking Quebecers hold the reins of economic power in the province, and the Charter of the French language, adopted in 1977, now requires all immigrants to send their children to French public school. So that nationalism, as it existed at the time, was very successful. However, this emancipatory nationalism was unable to translate into full political independence, as Quebecers twice, in 1980 and 1995, as you might know, refused to take the path of independence. They voted no to the sovereignty referendums. And faced with polls increasingly unfavorable to full independence, Quebec nationalists had to look for another adversary. And since the 2007 crisis over the Bouchard-Taylor report on reasonable accommodation in matters on religious issues, the nationalists have found their adversary within the Quebec population itself. A new nationalist discourse now preaches the need to protect against individuals and groups who do not share, or rather are represented as not sharing, the historical, cultural, and linguistic heritage of the French-speaking majority. This new type of nationalism has turned inwards, so to speak. It has refocused on the English-speaking minority and on religious minorities, both of whom are seen as being liable to jeopardize Quebec's vulnerable, distinct Francophone and Judeo-Christian identity. This is why both notwithstanding clauses have been resorted to in 2019 and 2022. The problem is not just the Canadian Charter as it was in 1982. The problem is human rights themselves. And that's what I find most troublesome, to answer your question. The nationalist discourse is no longer confined to justifying derogation to the fundamental freedoms enunciated in the Canadian Charter, but it also serves to justify doing without the fundamental freedoms guaranteed by Quebec's own quasi-constitutional Bill of Rights. Rights in Quebec right now are associated with courts, and in Quebec, the latter are depicted as dangerous and biased instruments of the federal will. This court bashing, according to me, could have dire consequences. When a government criticizes courts, it invites the public to do the same. However, a government of laws requires the existence of courts enjoying the public's confidence.
Should there be additional mechanisms that governments should use to test public buy-in before they invoke the notwithstanding clause?
Well, for the use of the notwithstanding clause to have legitimacy, it must reflect as best as possible a societal consensus, a consensus reached after in-depth deliberation about the issues at stake as to whether or not it's a good thing to resort to the derogation clause. Legislation such as Bill 21 and Bill 96, that's the statutes from 2019 and 2022, have been adopted by a simple majority of the voting members of the Legislative Assembly, and that is not enough, especially if the party enjoying a majority did not obtain a majority of votes, as is often the case in our first-past-the-post electoral system, and which is the case right now. The CAQ does not enjoy 50%, did not get 50% of the vote in the last elections. Even more so, when the legislation such as Bill 21 is rammed down the throat of the Assembly through the use of a gag order, fixing a very short time limit to the Assembly's deliberation over a challenged law. There wasn't time to discuss thoroughly Bill 21 because it was adopted under such a gag order. The idea to make this more legitimate would be to gather the largest consensus possible and the most enlightened one, enlightened by extensive public consultation under the supervision of a special legislative committee, but also, where the Quebec notwithstanding clause is concerned, enlightened by a report by the Commission des droits de la personne on the constitutionality of the bill tabled by the government. Such a report would enhance the quality of the discussion around whether or not it should be, Section 33 should be resorted to, or rather, Section 52 of the Quebec Charter of Rights. And to ensure the broadest consensus, the acquiescence of 2/3 of the sitting members of the legislature, not just those who vote, should be required to trigger the notwithstanding clause. The people's voice on such a fundamental question should not be confused with the will of a given premier, because sometimes the premier speaks for the Quebec nation, but he only speaks for his own constituents. And we need to expand the debate to make it broader, to make it more enlightened, as I said. If all these conditions were met, I believe it would reduce the likelihood of invocation. I think if we just having 2/3 of the sitting members of the Assembly, for instance, would require from the government in power, who usually does not control 2/3 of the House, would need to get the votes of some members of the opposition. So I think the discussion would be more profound, and the invocation of the notwithstanding clause less frequent.
I want to conclude with a question about the relationship between Section 33 and the federal character of the Canadian Constitution. How do you think about this relationship? Is Section 33 good for federalism since it gives provinces further leeway to interpret rights in their own way? Or does it weaken federalism by exacerbating intergovernmental tensions vis-a-vis rights issues?
Well, first of all, I think that Section 1 is more in tune with the federalism than Section 33 would be. What I mean by that is that I see Section 1 of the Canadian Charter and Section 9.1 of the Quebec Charter as providing what in European law we call a national margin of appreciation to each province. So under Section 1, you can take federalism into account when discussing if a particular rule is reasonable in a democratic society. For instance, in the Ford case, the court recognized that Quebec could legitimately be worried about the status of French in North America, in Canada. And so it did take into account the place of Quebec in discussing the Section 1. In that case, the court found that Section 1 wasn't satisfied because the charter completely prohibited French-only commercial signs. But then the court said it would be reasonable to make French predominant without excluding another language in commercial signs. So the court did think about, did take federalism into account in that case. And what's good also about Section 1 and Section 9.1 of the Quebec Charter is that under these provisions, courts are entitled to participate in determining a law's constitutionality, which is not the case where Section 33 is concerned. Section 33 removes all possibility for a court to, at least if you don't agree with Robert Legault, it removes all possibility for a court to determine the constitutionality of a law. In theory, Section 33 could be the means of reconciling federalism and national unity by allowing provinces a means of establishing their own understanding of the proper balance between individual rights and the common good. However, in our troubled and troubling times where populists abound, Section 33 seems to me a means of demonizing courts and at the same time of chipping away at our belief in the sanctity of human rights. What can we do about this? Well, this will maybe not satisfy you as an answer, but I believe the answer to whether Section 33 should be triggered or not, and in what ways, lies in part in the people electing members of parliament that in their very person exemplify what a French author calls le courage de la nuance, the courage to honestly embrace the complexity of a particular question. In our case, the question raised by the delicate equilibrium that should be set between respect for human rights and the common good. Such a person would have to confess to not having all the answers and be willing to deliberate with the loyal opposition on such questions. So I think, this question really is basically has to do with us citizens electing politicians who are not demagogues, who are willing to recognize, as I said, that this is highly complex and resorting to Section 33 needs prior deliberation. Unfortunately, few politicians seem capable to do that these days.
And that brings me to the end of my questions. Thank you so much for your time and expertise, John.
Well, this was very nice. Saloni.
We now speak to C. Strauss on Bill 21. Hello, C. Welcome to the podcast.
Hi, thanks for having me.
As you know, this podcast is about the notwithstanding clause in Canada. And LEAF has played an important role in the Bill 21 case, in which the Quebec government passed the bill using the clause. Today, we're particularly interested in how claimants have challenged this bill in court despite the government's invocation of the notwithstanding clause. But before we get into the litigation strategies, we'd like to rewind and start with the bill and its ramifications. So we hear a lot about the controversy over Bill 21. But this isn't just a philosophical debate. It's a debate over a law that is having very concrete impacts on specific groups in Quebec. Could you tell us a bit about what the law does and how it's negatively impacted certain groups of public sector workers?
Absolutely. So Law 21, or Bill 21, it's the act respecting the laïcité or the laïcité of the state. It's a funny word in English. Prohibits, among other things, people working in designated public institutions. So those are, the main examples that people cite are in schools, people working in education, police officers, lawyers in particular, like basically working in the Ministry of Justice in Quebec. It prohibits people in those particular institutions from wearing religious symbols in their workplace and from covering their face in the exercise of their functions. The covering the face part extends to a much more of the public service. But basically, in short, it prevents people from wearing religious symbols in their workplace, in particular public institutions. And that's had a disproportionate discriminatory impact on Muslim women in Quebec who wear a hijab or a niqab and who teach in schools. So it absolutely does violate the rights of religious minorities across the board. Sikh men wearing turbans, Jewish men wearing kippas, Muslim women wearing hijabs. But the majority of the people who have actually had their job prospects impacted are Muslim women who teach in schools. The National Council of Canadian Muslims just released a study about the impact of Bill 21 on Quebec Muslim women. They surveyed 411 Quebec Muslim women, and those women reported that since Bill 21 became law, they're facing increased levels of hostility at their workplaces, discriminatory treatment during job searches, a severe decline in their sense of belonging, and negative impacts on their mental health. So that report did poll a significant number. I can't remember, maybe 700 or fewer. I really can't remember, people who aren't Muslim in Quebec to just determine, what their experiences have been since Law 21 came into force. And disproportionately, Muslim women are facing those negative impacts.
So the main function of Section 33 is that it prevents claimants from using certain types of legal arguments to challenge a law. But we've seen with the Bill 21 litigation that there are still plenty of legal arguments that claimants can throw at a law passed using Section 33. Could you maybe walk us through some of the different legal arguments that were made in the Bill 21 case, despite the use of Section 33?
Yeah, absolutely. I'm going to only focus on a couple. There were so many arguments that were thrown at Law 21 and at the notwithstanding clause in this case. It's incredible. And I think that's why it took the Quebec Court of Appeal as long as it did to render their decision, because there were just so many arguments made. I'll focus on three. One of them I'll touch on only briefly. I think it's really interesting, but I just didn't work with it very directly, which is that Section 33 should be subject to Section 1. So given that Section 33 empowers a legislature to shield a statute from judicial scrutiny, is this an instance where that power can reasonably and justifiably be exercised? That would be the question. And this is coming from Brian Slattery, an academic, talking about this. So you would be basically asking, is the use of Section 33 by a legislature reasonable and justifiable? And so that's one argument that was posed. If the statute can't, on any reasonable view, be reconciled with the Charter, then the override declaration should be struck down. So I think it's a really interesting argument, but the Quebec Court of Appeal dismissed it pretty quickly. And I haven't actually spent enough time with the argument to really give my opinion one way or another, but it does seem that if you're subjecting Section 33 to the question about whether it's reasonable or justifiable, you're trying to import substantive limits on Section 33. And I think that is a very good exercise and effort but I'm not sure that the Quebec Court of Appeal felt necessarily empowered to accept it, given that the Supreme Court has said so strongly in Ford that the only limits are to be formal. So I think that that's just something that the Supreme Court is going to have to determine. Another one of the interesting arguments is that the courts should still be able to declare a law as violating charter rights, even if that law cannot be struck down as unconstitutional as a result. So this is about a declaration. If you issue a declaration, that doesn't mean that the law is going to be able to be struck down. Section 33 is in place. The notwithstanding clause was passed. That means that the law can continue to operate regardless of whether it violates any rights. But the argument that was made to the Quebec Court of Appeal was, please issue a declaration, as in please declare that the law violates rights anyway. And this will be useful. It will be useful for several reasons. It will be useful because at the end of the day, the notwithstanding clause is in effect for 5 years. That coincides with the maximum term that a government can stay in power. So when the government is leaving power, or, there has to be essentially a referendum on the government for many reasons, including their decision to use the notwithstanding clause through an election, it will be really quite helpful for there to be information as to whether the law that they passed violates rights when the public is making a decision about whether or not they want that government to stay in power. But it's not just about elections. It's also about the idea that to have an informed democratic debate, because the notwithstanding clause is only in effect for 5 years, the government will then have to repass the notwithstanding clause 5 years later, presumably with an informed debate. We actually know now, because the government of Quebec repassed the notwithstanding clause in May or June of this year to absolutely no debate. They pushed it right through. So this argument is unfortunately not as compelling as one would hope. But the argument is that when you have to repass the notwithstanding clause, you're going to have a debate about it in the legislature. And in order to actually have an informed debate, you would want to know whether, from a court of law, whether the rights are being infringed. Because that's all well and good. I think all of us can absolutely see that Law 21 violates, freedom of religion, freedom of expression, equality rights, and, the equality right, not just of gender, but of religion too. It's interesting because religion and equality rights is never really brought up because we just rely on freedom of religion. But the point is, it violates rights, and we can all plainly see that. But having that come from a court would be very helpful for then a future democratic debate on the effect of the law when you're repassing the notwithstanding clause. So there are a lot of reasons, even more than that, why it might be great to issue a declaration. That was another argument that was made. Another argument that was made about Section 33 is that Section 33, it actually applies to only certain parts of the Charter. So I'm not going to go into all the numbers of it because it's a lot to hold in your head. But the point is, it doesn't apply to all of our rights and freedoms. It applies to some of them. And there's a very little known, little used gender equality guarantee in the Charter at Section 28 of the Charter that the notwithstanding clause does not apply to. So, for instance, our equality rights, right? The right not to be treated equally, and not to be discriminated against on the basis of gender, religion, ethnic origin, race. That's actually something that the notwithstanding clause can override. Right? So the fact that, like we're saying, Law 21 violates the equality rights of women, in this case, Muslim women who wear a hijab or a niqab, the fact that those equality rights are violated doesn't, unfortunately, have any effect on whether the law gets to stay in power because of the notwithstanding clause. But then there's this totally other part of the Charter that says, notwithstanding anything in this Charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. So it's talking about, whereas Section 15, the equality rights, I'll just go back to that language, says every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination. That's talking about the law, right? Like, whatever law is being created, you have the right to equal protection and equal benefit. Section 28 is doing something different. It's actually referring to the rights and freedoms themselves and saying that all of our rights and freedoms, like the, freedom of expression, right to security of the person, right to life, all of those are guaranteed equally to male and female persons. So basically what that's saying is that you can't have any discrimination in the way that a government protects your right to life. There can't be any gender-based discrimination within those parts. So I know it's complicated, but here it comes. Basically, the notwithstanding clause doesn't actually override this part. So if we have a situation where the religious symbols ban, as I call it, but Law 21 disproportionately affects Muslim women, that's been clear. It's borne out in the evidence. The trial judge found that to be the case. It disproportionately affects Muslim women. Therefore, Muslim women's equality rights and freedom of religion are being impacted disproportionately. There comes around another part of the charter that says you actually can't impact one gender's rights or freedoms disproportionately. That is unconstitutional. So that's the argument, and that's the argument that was put before the court. There's a lot of work that has to be done to make the court agree with that argument, and that is actually something that really hasn't been done before for reasons I can get into if we want to. But this was one of the first places where that question was really put very substantially to the Quebec Court of Appeal, or to a court of appeal.
I'd like to pick up on what you said about Section 28 of the Charter, because I think a lot of people don't know that it even exists. So how do we end up with this specific gender equality section of the Charter, and what have the courts said about it in the past?
We ended up with it. The charter making process, in the late 70s and early 80s involved a lot of constituents. And there was a significant gathering of women that tried to put together recommendations of what should go in the charter that would actually push forward gender equality. Because the Bill of Rights, which was, our previous rights respecting instrument in Canada, was really a failure when it came to rights protecting, not just in terms of gender equality, but in terms of any equality affecting any marginalized group. It really stuck to formal equality. And so if we want to talk about the distinctions between formal equality and substantive equality, which was a big thing at the time to make sure that, the charter would actually think about substantive equality, what I'm talking about there is sort of what we now think of as equity. So we in law talk about equality. And when we do, what we're really talking about is the concept of equity as it's used now. So formal equality being like everybody needs to be treated the same, and substantive equality understanding that actually we need equity, which is that sometimes people need to be treated differently in order to have equality or to have justice prevail when it comes to people receiving, equal treatment under the law. Point is, a lot of the arguments that came under the previous Bill of Rights were such that you would get two people arguing that they were treated in a discriminatory way, and somebody would say, well, you're having the exact same treatment, so how could that be discriminatory? When in fact, we know that sometimes people need a different form of treatment in order for them to be treated equally. So that's what the concept of substantive equality gives you. The Ad Hoc Women's Caucus was very concerned that the charter wasn't going to actually take gender equality seriously. So they wanted there to be another provision that would absolutely guarantee that gender equality would be taken seriously. So they advocated very, very hard for the addition of another provision, not just the equality rights in Section 15, but another provision that would absolutely be a double guarantee that sex equality was finally going to be taken seriously by the government and by the courts. That's what it was doing there. And I can give you a little bit of more background to it, which I think is really important when thinking about the notwithstanding clause. What happened is there were a lot of different, as we know, pressure groups trying to motivate what the charter would look like. And so the feminists who were advocating for this provision to get in the charter did succeed, but there were a lot of different stages that the development of this provision went through. And at one point, it was going to say, notwithstanding anything in this charter except Section 33, the rights and freedoms referred to in it are guaranteed equally to male and female persons. So at some point during the development of the charter, people had gotten in to this gender equality guarantee that actually section 33, it could be subject to the notwithstanding clause, basically. So like, I'll read that again, notwithstanding anything in this charter except section 33. So there's a million double negatives going on there. But what it's trying to say is that you might have a gender equality guarantee, but the notwithstanding clause can still override it. And there was a huge outcry from this ad hoc caucus, but also from a lot of politicians, like very, names that we still know today, Joe Clark, Ed Broadbent, people who were saying that this had to go and that we couldn't be seen as saying that Parliament can be free to override gender equality, which of course is fascinating because what the notwithstanding clause does is it overrides all of our rights. So it does kind of beg the question, why would we be happy that it's doing any of it? But the point is there's a big outcry and that piece, except section 33, got removed so that now it says notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons, which I would argue should be, read in a living tree way to not just talk about male and female persons anymore. But anyway, the point is that that's a very strong argument that people made at the Quebec Court of Appeal as to why the notwithstanding clause should not apply to Section 28, because it was clearly contemplated to do so during charter drafting, and then it was removed. So it's a pretty clear indication, but the Quebec Court of Appeal disagreed.
As some of our listeners will know, the Quebec Court of Appeal recently issued its decision in the Bill 21 case, and it spent a lot of pages weighing in on these different claims that you just talked about. I know it's a very long, complicated decision, so could you maybe walk us through some of the key things that we should take away from the court's judgment?
Yeah, and I'm going to do so once again in relation to the declaration argument and the Section 28 argument, because again, there are so many different parts of this judgment. One part I wanted to get to that I didn't when I was just discussing is the argument about Section 28 and how it can be used is both that argument that's coming from the drafting part, right? Where it's like the argument about why the notwithstanding clause should not affect the operation of the gender equality guarantee. One is it was they clearly tried to do that in drafting and that was removed. So there must have been the intention when framing the charter that it shouldn't be subject to the notwithstanding clause. But the other has to do with this very complicated and very important understanding of what is actually happening when the notwithstanding clause is invoked. So I know this is, really getting into the legal part of it, and getting away from, the actual people who are being affected. But the way that the Quebec Court of Appeal approached both the question of can we issue a declaration and the question of is the gender equality guarantee something we can use to declare this law unconstitutional? The way they approached both of those questions is through the question of what exactly is happening to our rights and freedoms when the notwithstanding clause is invoked. You have the notwithstanding clause. The government says we're going to restrict people from wearing religious symbols in the workplace. And we know, and the quiet part is we know that's a violation. We're going to invoke the notwithstanding clause. What happens to our freedom of religion and equality rights when the notwithstanding clause is invoked? Do they exist anymore? And the reason why that's important is because if they don't actually exist anymore, then there's nothing to declare, right? There's nothing to declare a violation of anything if the rights have been, quote, overridden or exempted or all these different words that could apply, right? Or, quote, neutralized, which is a word that they use when they're talking about Section 28. And similarly, with the gender equality guarantee, as I was talking about before, it attaches to the rights and freedoms in it, right? So whereas the general equality guarantee we have in life is it applies to all Canadian laws, this gender equality guarantee that's extra only applies to the rights and freedoms in the Charter. So once again, if your freedom of religion is violated, you can't do that in a way that discriminates disproportionately against women. Okay. But what if your freedom of religion doesn't exist anymore because it's been, quote, neutralized by the notwithstanding clause? What does it matter whether you're being disproportionately discriminated against on the basis of gender in your freedom of religion when you no longer have freedom of religion? So the big argument was, what happens to the rights? Are they still there, really? And it's a weird question because it's so abstract. We're speaking in the abstract. But the main argument, and it was coming from the English Montreal School Board. It was also, I think, coming from Lausanne, but it was also coming from a paper that Robert Leckie and Eric Mendelsohn wrote on this particular topic. And they were really focusing textually on what the notwithstanding clause actually says, right? Because the notwithstanding clause actually says, and I'll read it here, when Parliament passes, this is not quoting, I'll let you know when I get to the quoting part, but when Parliament invokes the notwithstanding clause, quote, the act or the provision shall operate notwithstanding a provision included in the charter. That was not a direct quote. But the point is, it shall operate notwithstanding the rights and freedoms in the charter. And so what that means is the argument that parties who are opposed to the law were trying to make, and that people have made in academic papers, are that all that the notwithstanding clause is doing is permitting the law to operate. It's not saying anything about the rights and freedoms. It's not destroying them. It's not neutralizing them. It's not even overriding them. It's called the override clause, but that's not in the charter. That's just something that developed as a way we speak of it. But actually, when you look textually at what the provision is doing, it's permitting the legislation to operate. It's not cutting down the rights. So the argument is from the English Montreal School Board, the Canadian charter right is not abolished or cut down because Section 33 has been invoked. The statute is merely permitted to operate. And that, I think, is a great argument, and it's one that the Quebec Court of Appeal did not agree with. And what I think is vulnerable about the Quebec Court of Appeal's decision, and can absolutely be appealed from, which of course it's going to be at the Supreme Court, is that the reason that they gave for why they disagreed with that and decided that in fact it is an override that really does mean that the rights and freedoms no longer apply, is they took language from the Supreme Court of Canada's decisions over time discussing what Section 33 does and used it as proof. So there was a lot of language coming from the Supreme Court, yes, that says that the rights and freedoms, that says that the law is, quote, exempted, that the notwithstanding clause overrides the rights and freedoms. Absolutely. But all of that was all in what we call in law obiter, which means they were just they were talking about what Section 33 does, but they weren't actually faced with a question of what happens to the rights and freedoms, in reality when the notwithstanding clause is being invoked, because they weren't actually speaking in cases when the notwithstanding clause had been invoked. So they weren't turning their minds to the real question that was at issue in the Quebec Court of Appeal before the Quebec Court of Appeal. And so it doesn't really make sense, in my opinion, for the Quebec Court of Appeal to have taken essentially throwaway comments. I mean, of course, the Supreme Court doesn't provide throwaway comments, but we know in law that you can't really rely on a Supreme Court statement unless it's focused on the issue at hand. And all of the statements that they gave were not focused on the question of what happens to our rights and freedoms when the notwithstanding clause is invoked in a way that was actually going to have a legal consequence in the case when they were saying it, because they were never actually making those statements in the case of the notwithstanding clause having been invoked and having to decide whether the right or freedom still exists. So the Quebec Court of Appeal took a lot of language from the Supreme Court in a way that doesn't actually mean that any of it was legally binding. And so it'll be interesting to see how that goes up on appeal.
Thank you so much for your time and insights, C.
Thank you. Thanks for having me.
Today's episode explored the notwithstanding clause through the lens of Quebec's unique and long-standing relationship with it. We also heard about some creative ways people are challenging Quebec's secularism law in court, despite its use of the notwithstanding clause. In the next episode, we continue the story by traveling out west, where we delve into the clause's use in relation to queer and trans rights in Alberta and Saskatchewan. Thanks for listening.